all angles of it, from the prosecution side, the defense side. There's going to be no real like discussion about whether that the conspiracy is real. It's not. We'll discuss it, how it's being played by the jury and what they think of it. But at no time we're going to be acting like this is a real thing. I have long believed that the best avenue for the defense is not the conspiracy. It's actually reasonable doubt, or just the investigation itself, what it was flawed, that there were holes in it, that there was people who were compromised if it were. So that's where we're going to be focusing our the analysis of this case. We're going to talk about one or two issues every single night with this airs. So usually we're going to go once a week live. The other one will be recorded, or some weeks, depending on what's going on, we might do multiple live shows. It will usually be 6:30. This is just a special example of, where technical issues, you got to just do it on the fly, just roll with the punches. As to jury selection, what I can tell you is this. Sun Tzu's The Art of War had a phenomenal quote once upon a time. It is, every battle is won and lost before it is ever fought. In a criminal case, that exact situation is jury selection. The reason is because when you can lose your case before you even have the first witness speak if you pick the wrong jury. That's what I can tell you. Because if you have people on the jury, which I think occurred last time, who had already made up their minds before they even heard the evidence, that case was doomed from the start. And think of how much time was spent on it. It was like an 8-week trial. I think it started in April and then didn't finish till the week of July 4th. That whole trial was already over before they even did the first witness. And that's because it was pretty clear when you heard from the jurors who were willing to speak out on Karen Read's behalf. And then it's like, okay, there was a deadlock. But what was interesting is none of them really ever bought the conspiracy. When they talked about the case, they were like, all right, well, we had issues with Michael Proctor. Yeah, everybody does. It was pretty clear he shouldn't have been working the case. Once he got to the crime scene, he should have conflicted off. It's like, you need to send somebody else out here. That was mistake number one. Mistake number 2 through 1,000, pretty much, were everything that was brought out in trial in the first case. And I definitely believe that when this case is, as it's being retried, you're going to see a kind of a similar thing on how they approach his testimony. They're not going to hide from it, because I remember there was a bunch of people online thinking that, oh, they're not going to call him. It's like, he's the lead investigator on the case. His investigation may have been atrocious. His attitude and how he conducted his professionalism was ridiculous and completely conduct unbecoming an officer and a Massachusetts state trooper. But the results were not flawed. They did not get the wrong person based on what was presented at trial. Was it compromised? Arguably, yes. Was there issues with the Sally Port video being inverted maybe more than it should have? Yeah, probably, but it doesn't look great. What I can tell you is, in this case, this trial is going to be won and lost in a courtroom. That's where trials are won and lost. They're not lost on the internet. They're not won on the internet. They have individuals who take the witness stand and then they present facts and evidence. That's what a trial is. It's based on facts. So when we're doing these streams and interacting with people and answering questions, what I can tell you is this: we're only going to be talking about facts and evidence. We're not going to be talking about conspiracies that don't exist, or talking about the Canton audit, which is not going to be admitted at trial. I think it came out today. That's not going to be an issue. We're going to talk about jury selection. We're going to be talking about the juror who, on the first case, who's now on Karen Read's defense team. We'll be talking about what each side is looking for in a juror. All of those things that will go into what actually means to try a case and to get us to sustain a conviction or get an acquittal, because I've gotten both in my career as both a prosecutor and a criminal defense attorney. Starting with jury selection, what I can tell you is this: the prosecution is going to want people who are law enforcement based, who are military. They're looking for a 4-person, late 30s, early 40s, somebody who can be the alpha male, who could run the jury and with being the foreperson. And you want that person on your side because they're going to be the ones that are going to make sure deliberations go okay. They're going to be the ones that decide whether or not what voting is done, what evidence is considered, how it's all being done. Because as we saw in the first case, they were out 18 hours or whatever. So you need somebody who is going the foreperson. You need them to be in your camp from the first witness. And if you choose the wrong person or you don't ask the potential foreperson enough questions and get information, they're going to be that's not going to be good for your case. You don't want to spend another 6 months after getting another mistrial, having to comb through the evidence and convince the people of the Commonwealth of Massachusetts that it's worth retrying this case again. I honestly believe that, yeah, I saw that it's like they're going to try it as many times as it takes. That's what they're saying. I don't know if the prosecution is going to want to retry this for a third time. They might have to move it to another jurisdiction. But what I can tell you is you have Special ADA Brennan. You have a different case, same case, same case, but you have better evidence, hopefully, this time. And what we saw with the motions, it's like, all right, we're actually going to potentially bring in Aiden Kearney to testify against the defendant. That could be a monumental moment. There might be nothing. We don't know. And that's the beauty about this case. Like, we're not going to know until that individual takes a stand. We're going to know a lot of the facts already because we've been through this trial again. We know that the defense is going to make a big thing about the inverted Sallyport video. They're going to talk about 227, how long to die in the cold, which was debunked, but that's an issue of fact for a jury. There's also going to be this new added thing of the pedestrian strike. At the first trial, the prosecution, which I've said before, did not do the greatest job actually explaining it. They showed the evidence that is pretty clear that John O'Keefe was struck by a vehicle, but they didn't prove it beyond a reasonable doubt. It's like they had the evidence was there, but it wasn't enough to just convince any people to remove any kind of doubt in the case. And did it help that people on the jury were never going to convict? Yeah, probably. But at the same time, it still could be better. It still could be like, all right, let's eliminate any possibility that the hairs of John O'Keefe were planted on the vehicle. That's a big contention because it's either he got hit and it stuck there because it was cold or it was planted. Those are the two options. So if you can eliminate the planting, and the conspiracy angle, all that's left is he had to have been hit by this car. It's like, why are pieces of the taillight in his clothing? The officers can't pick them up. So if they can't pick them up, how do they plant them? They can't exactly. So I can tell you about this. It's what you're going to experience when we're doing jury selection. It should last a couple of weeks. Prosecution, like I said, wants people who are by the book, black and white. This is the law. I'm going to follow it. The defense wants the opposite. What I can tell you is the defense wants people like teachers, as an example. Teachers are great jurors for defense attorneys because they're so used to hearing both sides of the story, not accepting what's being presented to them at face value, and knowing that there might be a bit more than what they're not saying. So they're always going to be skeptical going in. If you're the prosecution, you want to get as many of teachers off your jury pool. You don't want them on it. But at the same time, you're probably not going to be able to keep everybody off because you have unlimited cause challenges. But if you can't cause challenge somebody who's like, I haven't really made up an opinion, but I feel like I had a bad experience with law enforcement, and I feel like she may have been framed or something like that. And it's like, it's possible that could be a cause challenge, but more likely than not, you're going to have to use a preemptory. In the Commonwealth of Massachusetts, when you have a case that is punishable by life imprisonment, which is here, a second-degree murder case, you get 12 preemptory challenges. You need to use them wisely because once they're done, they're done. You can't use them anymore. You don't get any more. So you start by using your cause challenges, and that's for people who have preconceived notions about the case. I think today, for example, there was like 100 people, and about half of them had already formed an opinion. I think I saw like 18 had already biases. Those people are gone. Anybody with biases are not going to be sitting on the jury. People with opinions are going to have to be thoroughly examined during voir dire. And if they're like, yeah, I think I've kind of made up my mind, those people aren't on the jury. And then the rest of the people, it was something like 85%, I want to say, had heard about the facts of the case, which are kind of low for all things considered, considering this is like round the clock news everywhere in the Commonwealth. And so you're like, okay, this is kind of what we're dealing with. People who've heard about the case, who might be familiar with it, but we need to figure out who are the ones to actually have a situation where um, who are who are the best people in this case? Who are we going to actually want on our jury? And sometimes it may not be, we're not going to always get what we want. The prosecution is not going to be able to keep every single person off the jury they want, just as the defense is not going to be able to do it. What you are looking for is 12 to 16 people talking about who are as fair and impartial as humanly possible. That's what you're looking for. Because remember, both the Commonwealth and the defendant are entitled to a fair and impartial jury. That is the bedrock of our system. If both sides don't do that, don't have that, then our system itself is going to be, you're going to get unjust verdicts. Like I've said before, I was on live now from Fox earlier today talking about this case. Our judicial system is flawed, but it's still the best there is in the world. And when you're doing this case, you're trying to find people that are going to be open to hearing the facts and evidence. A perfect juror is someone who comes in not having thought about the case at all, but that's kind of not likely to happen in this case. But somebody who's open to hearing the evidence and willing to not make up their mind till they hear all of it. That means the prosecution's case, the defense case, and the potential rebuttal case. That and only then, when you go back into deliberations, are you then going to talk about what you saw. I've had cases where juries have been out for, I think I did once a DUI case. It was so clear that the defendant was guilty. I think we got him convicted in 6 minutes, and that was only because it took 3 minutes for them to pick a foreperson. And other cases where it took 8 hours for deliberations to happen, and sometimes more. I'm coming into an big attempted murder case in a few weeks. The jury could be out an hour or they could be out a day. It all just depends. And what I can tell you is this is so important what they're doing right now and being able to pick that jury. It doesn't seem like there's much issues for what I've seen, because it's like they're asking the right questions. They're finding, because to get 2 jurors today, that's much more than I thought. I think they're going to bring in 2,000. So I think they're going to impanel 16, 12 is in the primary panel, and then 4 alternates. So if something happens, it's going to be a long case. Some people might not be able to get to the end. Some people might be excused. That's how it is. So they did get 2. I think, yeah, I saw that in the comments. They did get 2. I think the defendant put up 2 fingers to Ted Daniels or someone from Channel 5 saying they got 2. But that's pretty good. They're probably going to do the same thing tomorrow, another 100 people. And you're just looking for those people. You don't want to make the same mistake. Adam Lally did a commendable job on the first trial, but it was pretty clear that there were people on the panel, like I said earlier, who shouldn't have been on there, who had already made up their minds before hearing the evidence. Those people should have never been allowed to be on the jury. And I don't think that's going to happen with Special ADA Brennan. But there was something I spoke about on a live now from Fox. This ability with a potential for like a sleeper juror, a juror who kind of keeps their mouth shut and keeps their opinions to themselves with the hope of getting on the jury so that they can use whatever fixed notions and opinions they have, whatever they may be. So that's why it's very important you speak to everybody when you're doing voir dire and finding out exactly. So you wonder why they fill out questionnaires where they're talking about, it's like, oh, what newspapers? Nobody really reads newspapers. I still do, but like what magazines, what TV shows, what you do for a living, whether you're single, divorced, married, all of that is giving information to a trial attorney depending on the case. This is a murder case where alcohol is going to play a factor in this case. So what you don't want is people who've had previous DUIs who thought that the system screwed them over. They're going to carry those opinions over into this case. They're going to hold it as like, well, law enforcement unjustly arrested me and treated me unfairly. If that person says to you, "Oh, I can set that aside," they're not going to be able to do that. When I had an aggravated assault with a deadly weapon case when I was still a prosecutor, I had a juror who told me that her experiences with her father not like approving of her boyfriend and stuff like that, and they got into a fist fight. She told me up and down that had no ability, she wouldn't affect her ability to be fair and impartial. So I'm like, okay, well, we can't really strike her for cause. She says she can be fair and impartial. I didn't see anything that would preclude her um, from serving on the jury, so she was let in. The problem was she did allow her preconceived notions and her personal opinions affect the case. You know, I know that because another one of the jurors called me and said, "It's like you asked us unequivocally, but during voir dire, if we could set our personal opinions aside, and we all truly believed we could do that." That's the truth. We all thought we could, but in the end, we couldn't. When we got into the jury room and deliberate, all we did was bring in our preconceived notions about the case, about our personal feelings. So, and someone like Special 88 Brennan knows that once somebody says that, they can't set it aside. You got to get them off the panel. It's that simple. You can't risk that situation with somebody being on the panel and having this preconceived notions, thinking that the defendant is guilty, the defendant is innocent, without even hearing any of the evidence and being unwilling to come off of that opinion. There's nothing more scarier than that. What I can tell you is this: as the defendant, until the defendant is proven guilty beyond a reasonable doubt, she's innocent. That's when you say she's an innocent woman. Yeah, that's true because she hasn't been convicted and the evidence hasn't been presented as such. And it's going to take a while because you know how the trial is going to start. It's going to start pretty similar and it's going to go in chronological order, what they were doing. Hopefully, this time we're not going to spend a half hour talking about glasses and stuff from the waterfall. I did have an issue with that when Adam Lally did that. I did say that as much on court TV. But let's get to how many drinks this individual did, how and eliminate each and every person one by one. Because there are two primary cases to prove a case: a direct evidence case, which means is that all the evidence points in one direction, and everything you put forward points in only one direction, and that's the defendant's guilt. But with this having a conspiracy element and creating this built-in reasonable doubt because of the investigation, now you almost have to prove it like a circumstantial case. A circumstantial case is proven by eliminating each and every other person who could have done this but the defendant, and that's the only person that remains. So you have a direct evidence case that you're going to have to prove in a circumstantial manner. And I definitely think that's why someone like Special ADA Brennan was brought in, having been a defense attorney his entire career and knowing how to ask the questions, know how to prepare the case, and know exactly what the defense is going to do before they even do it. Because, yeah, Alan Jackson and David Yannetti are seasoned attorneys. They've already been through this trial. Special ADA Brennan has not. And so didn't the new alternate juror who's serving on the case that we're going to discuss. I was asked like a question: could she be reported to the bar? It's not illegal or unethical for her to serve on this jury. She wasn't part of deliberations. And as long as she doesn't stand up during like opening statements or be like, I was a juror in the first trial and the prosecution and the state proved were so awful that I had to represent her on the second case. She can't do that. That would be stricken from the record and probably grounds for a mistrial. What I can tell you is this. Most likely she's just going to be giving her knowledge of like, what was it like being in the juror room on the first case? Like, what did you guys focus in on? That's where I think her real knowledge is going to be. I don't think she's going to be like a juror consultant, like, oh, you want this person? No, I am talking from my experiences as a juror in the first case to help you with my experience as an attorney trying to get an acquittal in this case based on what we found persuasive and what we didn't find persuasive. And as we know, they didn't find the conspiracy persuasive at all. But the integrity of the crime scene, the fact that it's like yours red Solo cups, those are all going to be issues. The fact that everybody hears her say, I hit him, I hit him, I hit him, but nobody writes it down. Those are where the case should be based upon, because that's kind of like, oh, okay. It's like, but this idea that like 40 people came together and like Brian Higgins and Brian Albert. Nobody bought, the jury didn't buy that. And as we saw with the judge's third party culprit motion, it's definitely it didn't fly with her. And I don't think it's going to fly with a juror. Let me see. I got a question. Did you see the CW's, the Commonwealth's motion today inquiring about parameters or investigating possible jurors, looking at their social media? I did not see that, but it's not something that would be outside the realm of possibility because they want to see, because jurors anybody can say anything they want. But if you do a little investigating, you want to make sure that the individuals that are claiming, I have no preconceived bias whatsoever. And it was like, but you have all this like anti-Karen Reed or free Karen Reed stuff on your part of this group, and you're donating or to this, that, and the other things. Like, that's not really what you were telling us. So it definitely, I think it's part of the game to make sure it's like, think of Ronald Reagan, trust, but verify. What's your thoughts on Aidan Kearney's motion to accept him for sequestration? Judge Cannoni's never gonna grant that. She's not gonna be like, you're a journalist first. She is very aware of Aidan Kearney and everything that he has done, and she is, as Special ADA Brennan listed him as a witness. I absolutely think Judge Cannoni is not going to give him a special exemption as a quote unquote journalist. And that's because when you have a criminal trial, all witnesses are subject to sequestration before they testify. That means they can't speak to the other witnesses. They can't be watching it. They can't be in the courtroom. The only exception is kind of like a police officer or a lead investigator or something like that. So, but Special ADA Brennan is not going to want the optics of, say, Michael Proctor sitting in the gallery the whole time. He's just not going to want that conversation, what's going on. And so I definitely think that Aidan Kearney is probably going to be sequestered until he testifies, if at all. And if he did, it'd probably be very late in the case to maximize. And then even still, they might not even release him from a subpoena to call him in rebuttal. So I have a feeling that he's not going to be in the courtroom. He's going to be he could be talking online. It's like, well, I heard this or this, that, and the other. And he can really test the bounds of the rule of sequestration, but I don't think that's the smart move to make. What I can tell you is this: this case is going to come down to two primary things: the vehicle data and the pedestrian strike. What we didn't have in the first case was they didn't really explain how, like, all right, where was the car at certain points. It's kind of like we had like ideas and about where it was, instead of like at 12:30 it was here, 12:32 it was here. And I was like, because one of the things for me that I watched in the original case was when she backed up the ring cameras, that we don't have the other video, wherever it is, it doesn't matter. We're not going to speculate where it is because it's not in evidence, and we're not going to play the conspiracy game. But one thing that I want to see potentially discussed, if they have the information, great. If they don't, then don't bring it up, is when she backs up into John O'Keefe's vehicle. I grew up in the Commonwealth of Massachusetts. I was born in Quincy, Massachusetts. Yes, but no, I do not know Michael Morrissey. For the 50th time, 50,000th time I've been asked on the internet. And all of us have driven in the snow. Yeah, sure. She's probably still drunk at the 4 or 5 a.m. this happens. But you watch, she doesn't even try to evade the car. She like backs up directly into it. So that's an interesting thing. It's like, I want to see if that can explore. But also then talk about the accident reconstruction. Don't have the same guy do it. Have your own person to discuss it. And have somebody else explain it and be crystal clear of what happened and what it means. I think the medical examiners did a good job explaining it. I don't think it's that huge of an issue about that it was the cause of death was initially ruled undetermined because the choices were accident or homicide. And this case it's kind of redundant if it were. It's not a situation where they're arguing it's like, oh, he accidentally killed himself or something like that. It's like he fell down. That's never been their defense. It's either he got struck by accident, he got struck on purpose by the vehicle, or he got brought into the house and beat in the basement and then thrown on the front lawn. So that really doesn't matter. Um, Question: how does the former juror provide any insight regarding jury discussions? She was an alternate. She wouldn't know. That's an interesting question because she can tell you, she can talk about what she perceived up until deliberations. So, what she was viewing, her personal thoughts, because she may have not have talked in the deliberation room, but they still talk about what they said. They're like, "Oh, well, like, whoa, what do you think about that, Michael Proctor? Wow, that was some crazy stuff. Shh, we shouldn't be talking about it." Or just like, "Oh, well, that juror heard the whole case before and was able to give, what'd you think about this?" Because if you watch the documentary, they're going and watching replays like Bill Belichick watched film, and they're like, "Okay, like, how are we going to do this? How can we make this better?" So I definitely think that that's kind of um, I think that's where her insight's going to be. Do you think they will get murdered too? They need to explain the pedestrian strike better because the idea that they were where the murder two comes in is that she had to backwards accelerate way fast at like 26 miles an hour and hit him. That's and they didn't really do that. The person like said the facts, but nobody, even me, I understood what they were saying, but it still wasn't clear, and it definitely wasn't proven beyond a reasonable doubt. So unless they have a much clearer intent to do grievous bodily harm for second degree murder, I don't. It's going to be an uphill battle. So we'll see what they have to prove it. Maybe there's information on the vehicle that wasn't presented at trial because in the first trial, murder two wasn't proven beyond reasonable doubt. What was it? What are your thoughts on Brennan saying that he doesn't intend to call the medical examiner? Her whole vibe in the first trial was odd. I it was I don't know what the medical examiner is going to provide. It's going to say it's undetermined, and they originally were not going to call. I think they tried to do a motion in limine to try to keep her out, and they're like, no, she can testify. I don't know if she necessarily the medical examiner, it's not going to hurt or help one way or another, but I think the jury's just going to want to hear it, so they're not thinking, why didn't they hear from this person? I definitely think that um, what's going to be interesting this time. They have James Crosby, who's going to talk about the animal attack and the alleged and that it didn't happen, and then Marie Russell's going to say it did. And but this time around, the defense is not going to be able to hold up the ARCA witnesses as independent. And if they try to do that again, that's not going to fly. And in fact, when they tried, it's like, oh, well, you were hired by the feds and everything like that, and we have to play that game again. Um, what I can tell you is this: is that the ARCA witnesses are not going to be given that much credence, much more like credibility than they were the first trial. The first trial, they were like these holier than life people. It's like, this is what they said. It's like, but remember, I'm a criminal defense attorney, plaintiff attorney. Experts will usually say just about anything if you pay them money. So if you find somebody, they'll create any kind of scenario to get you paid. So what I can tell you is this, and this case is going to be tried in a courtroom. It's not going to be tried online. And that's people need to remember that. It's like, I'm going to talk about facts and evidence on this stream. We're going to talk about it a couple times a week. I'm going to take questions, but there's going to be no time for, I'm not going to any time calling people to McAlberts or being like, oh, well, you a cunt, Auntie Bev, and all the ridiculous stuff about seeing. It's like, no, this is a professional case. This woman is on trial for her life. So let's show the respect that our judicial system deserves. And that's all what it's going to be about. When I engage with people online, especially some of the things, including what I've seen on this case, I've never seen before. But at the same time, it's never going to scare me off from reporting on the facts. I can tell you've had people literally leave fake Google reviews for me, for my law firm on Facebook, Google, never had me as a client. It says all these terrible things. And then it'd be like from some 774-508 number. It's like, I'm a Florida attorney. I'm originally from Massachusetts, but I don't have, I worked as a law clerk at a Boston law firm, but I don't have clients up there. So I know you're kind of not telling me the truth. Um, have you gotten the yellow page style book of expert witnesses sorted by speciality? I got one as a 2L or 3L. Um, yes and no. It's kind of what I can tell you is expert witnesses are in criminal cases somewhat not as important as civil cases because but at the same time, they are like an impartial, like jurors, when they hear expert witnesses, their attention is zeroed in on it. So, one of the biggest mistakes I will tell you, because we're going to wrap up soon, in the first trial was Adam Lally did not put his best witnesses at a time where a jury's attention is going to be at its maximum. Here's what I can tell you: you never want to put on your best case, put on your best witness at 9 a.m because people aren't paying attention. People haven't had their coffee, they haven't settled in. So from 10 to 11:30 a.m., because once 11:30 starts, people start thinking about lunch and their attention is not as great. And what I can tell you is this: you want to put on your most important witnesses from 10 to 11:30 and then from 2 to 3:30 because that's when people are going to be paying attention the most. That's when you put on your best witnesses. And expert witnesses, when you put them on, the jury's going to be listening to them. They're going to take what they're saying as gospel. And it's very, very important that you put them at a time when juries are paying attention. Uh, Mondays and Fridays are not the best time. They're kind of like, here are your procedural witnesses. Tuesday, Wednesday, Thursday are the best times for getting information out and soliciting the best amount of testimony when they're taking notes. And that's just kind of something, and that's something that takes practice. People who haven't done many trials, that's not something they would know. In this case, only, yeah, I don't know if that's a question. What I can tell you is this. Um, in the original case, I thought vehicular manslaughter was probably the most prevalent charge. I think that was what was proven. I don't think the murder case was proven beyond a reasonable doubt. Like I said, this case starts over again. The defendant is innocent until proven guilty. We're going to talk about this case throughout the trial. And that's all we're going to do. We're not going to be like, oh, she's guilty. They said I had him, I hit him, I hit him, I hit him. That's not enough. That's not enough. You've got to literally put her behind the wheel of the car, and you have to put the vehicle being used to strike John O'Keefe. You need to have all of that to be able to get the vehicular homicide, and that's why they had like the 9 drinks. I always thought the best last witnesses for the state would be the niece and nephew. That's a very, very interesting thought because they were absolutely lethal witnesses in that case because they overheard John O'Keefe say to Karen Reed, it's like, I think our relationship had run its course. They were always fighting. So that it kind of is like, you can't even cross them. It's like they've already lost their mom and dad, and then they lost their uncle. You can't really discredit them. And they're saying it's like it's like, all right, well, it makes sense about what it is, and makes sense why it's like why they eventually broken up. And it would be interesting. I want to know more. And they did come. What was interesting about the documentary is like he walked out without a glass from waterfall, something like that. What is possible? I almost felt like the most likely scenario. They're in the car and they get into a fight. John gets out of the vehicle. John walks around the edge of the vehicle. Remember, it was all snowing, so I don't think he could have walked forward because otherwise that's what he would have done. So he walks behind the car, and without knowing it, the defendant backs up and hits him. Or it's the victim gets out of the car and is kind of like the defendant and her are arguing, and then she drives off. He throws the glass at the vehicle. She backs up and hits him, thinking that it's like, I'm going to be funny and come back and screech the tires, like trying to scare him into think I'm going to hit him. And then you do it by accident. That's kind of the two most likely scenarios for this case, or about how it actually makes sense, because the body is found under the tree, which seemed to be about 30, 40 feet from the driveway. So unless the victim, John Officer O'Keefe, got hit and then was kind of like woozy and whatever and walked over to there, I think what happened was, so whatever it is, I want to hear what the theory of the case is for Hank Brennan, because the jury's going to want to know what happens. Like, they don't need to prove a theory, but it makes it easier so that jury can be able to follow it. So that's where we're at with this case. We'll do the next live stream on Thursday, probably 6:30 or so, depending on what's going on. I do have a huge stand your ground hearing on an attempted murder case, so fingers crossed. I don't know about it, so we'll see what happens. And in the interim, we'll see what new twists and turns they have in this case. Like, having one of the jurors as a defense attorney in the retrial feels like a Lifetime movie. I feel like Jessica Capshaw was like One Angry Jury, a Lifetime movie or something like that. That's what it feels like. But thanks for tuning in, and I will be back on again Thursday night, probably 6:30, and discuss more. Thank you.